So thank you for being here. I grew up with Harry and Niall through nursery, secondary and primary school. Harry was a great person who was very caring and was taken too soon, driving perfectly safely on the right side of the road. The way that the US government has treated with this family with utter disdain, all the family wanted to do and all Charlotte was interested in was to hear an apology and a mere explanation as to what happened. She never wanted to take Anne Sacoolas away from her kids. And a message to the US government from the younger generation is, you're not our friend. This is not how allies treat one another. This has turned into a massive international dispute, but I've spent time with the family every day, and what they have to go through on a daily basis is awful and unacceptable. But this is not an isolated incident. The US government are treating many families like this around the world, as much as they try and hide it. And I would just encourage you to watch this space, as me and my team will focus on exposing them and fighting them on every corner. And thank you very much.
At no point in these proceedings had it been suggested that you were not free and able to travel to this jurisdiction in person. Once you had pleaded guilty and were therefore a convicted offender, there could be little reason in a case where a young man had met his death for you not to be required to attend at court for sentence. Your bail was not withdrawn and you were released from the court but directed to attend in person for this sentencing hearing. I directed you to attend and observed that attendance in person would be strong evidence of remorse. For the purpose of Section 6.1 of the Bail Act 1976, you had a duty to surrender to the court. Failure of a defendant in a criminal trial to attend in person when directed to do so without reasonable cause is an offence contrary to the Bail Act. It has the potential to affect the court's ability to administer justice by damaging the confidence of victims, witnesses and the public more generally in the effectiveness of the court system. Judges have to consider taking appropriate action if there is no sufficient justification for a failure to attend. The usual action is to issue a bench warrant not backed for bail, which will result in the arrest of the defendant when they are located. Your sentence is due to take place on the 1st of December. A week before that date, on the 24th of November, the court received a renewal of the application for you to appear by live link. This included references to harassment and threats you and your family had received, mainly by social media, and many emanating from the United States of America, and an assessment that this gave rise to a risk to your personal safety if you travelled to the United Kingdom. It did not include any reference to a barrier imposed by the government authorities to your travelling to London to face sentence in person. As a consequence of what the court received, I asked the prosecution to provide a response to the material submitted. Very swiftly, by the 28th of November, the Northamptonshire Police compiled an operation which set out in detail 4 plans by means of which your safety could be protected if you were to return to the jurisdiction to be sentenced. Accordingly, I maintained my order that the hearing be in person. However, a request was made on your behalf for a delay of a week to obtain further evidence. This was allowed. On Friday, the 2nd of December, a statement was served from Amy Jeffries, your attorney, who accompanies you today, and I granted the application on Monday, the 5th of December. The reasons were that for the first time in these criminal proceedings, a barrier to your attendance emanating from the American government was relied on in support of the application. In her statement, Ms. Jeffries says, quote, "The US government does not in any way support Mrs. Sacoolas's appearing in person at this hearing, In fact, Mrs. Sacoolas' US government employer has advised her not to return to the United Kingdom in person for this hearing because her return could place significant US interests at risk. This advice was communicated to her by her employer on the 30th of November, and she is not at liberty to disclose the communication itself or any further information to the court.